CPL 720. As the term is defined in Article 720, a youth is a person 16, 17, or 18, as 16 and less than 19, who is charged with a crime, or a person being charged with being a juvenile offender. 720.10 sub 2. Eligible youth means a youth who has not been convicted of a Class A1 or A2 felony. 2. Convicted of an armed felony with no mitigating circumstances. 3. Been previously convicted and sentenced for a felony. And 4. Been previously adjudicated a youthful offender after being convicted of a felony. 720.10 sub 6. A youthful offender adjudication consists of a youthful offender finding and a youthful offender sentence. So it parallels the regular case. So in a regular adult case, you have the conviction, then the sentence, and the two of them together equal the judgment. In YO, you have the finding plus the YO sentence equals a YO adjudication. So the finding is parallel to the conviction, the YO sentence is parallel to the sentence, and the YO adjudication is parallel to the judgment. A youthful offender adjudication is not a judgment of conviction. Finding plus the YO sentence equals the YO adjudication. 720.35. A youthful offender adjudication is not a judgment of conviction, does not operate as a disqualification to hold public office or have public employment, and it does not operate as a disqualification for licenses. 720.15. When an accusatory instrument against an apparently eligible youth is filed with the court, with no one's consent, must order that it be filed as a sealed instrument, though only with respect to the public. The thing that talks about like the defendant requesting or consenting or something, that has to do with about excluding everyone in the courtroom. The sealing, there's no consent required. The court is automatically required to seal the instrument with respect to the public, which is why if you work in criminal court, this law was not around when I began working in criminal court, and everyone's name printed on a calendar. Now, because of this law, an apparently eligible youth, their name will not print on the public's calendar. 720.15. The procedure above does not apply when 1. The pending charge is a felony, 2. The youth has previously been adjudicated YO, or 3. The youth has been convicted of a crime. So, the procedure above does not apply when 1. The pending charge is any felony, or 2. The youth has previously been adjudicated a youthful offender, YO, or 3. The youth has previously been convicted of a crime. 725.05 sub 7. If a case is removed from criminal to family court, the criminal court must issue an order of removal, and whether or not a securing order has been made, must specify a date certain, not more than 10 days from the date of the order of removal for defendant's appearance in family court. And I think if they're in, it's the next day court's in session. 725.05 sub 9. Order of removal must be signed by the judge or justice that directed it. 725.10. Upon the filing of an order of removal, the criminal court action is deemed terminated. CPL 720.20. Upon conviction of an eligible youth criminal record, and by not imposing an indeterminate sentence of imprisonment of more than 4 years, the court may, in its discretion, find the eligible youth is a youthful offender. So again, this is about someone who is charged with a felony, most likely. And it says, upon conviction of an eligible youth. Now, I want to check that, because I believe that is wrong. I believe that it's supposed to say at the time of pronouncing sentence. Okay, so this is why I got this question wrong because it was towards the end of the criminal articles. And so I didn't read this out of the book. And because even though I saw the ... back in 2007, I didn't know the ... meant that you were supposed to go and read the book and see what language was skipped in the article. So I didn't. And I just memorized the way the question was written. So that is why I got it wrong. Because what it actually says in the book is, upon conviction of an eligible youth, the court must order a pre-sentence investigation of the defendant, period. Upon conviction of an eligible youth, the court must order a pre-sentence investigation of the defendant, period. Next sentence says, after receipt of a written report of the investigation and at the time of pronouncing sentence, the court must determine whether or not the eligible youth is a youthful offender. Such determination shall be in accordance with the following criteria. Now, this is where it starts talking about the criteria. This question, the way it's worded on Frank's practice test, if you do not go and look at the book every time you see ... you are going to do what I did on this question. You're going to memorize it without knowing what's in between. So, this question was a question about the criteria. So here's the criteria. 1, if in the opinion of the court, the interest of justice would be served by relieving the eligible youth of a criminal record and by not imposing an indeterminate term of imprisonment of more than 4 years, the court may, in its discretion, find the eligible youth is a youthful offender. And B, now this is MYO, mandatory youthful offender, where the conviction is had in a local criminal court and the eligible youth had not, prior to the commencement of trial or entry of plea guilty, 1, been convicted of a crime, or 2, been found previously to be a youthful offender, the court must find he is a youthful offender. 2, where an eligible youth is convicted of 2 or more crimes set forth in separate counts of an accusatory instrument or set forth in 2 or more accusatory instruments consolidated for trial purposes, the court must not find him YO with respect to any such conviction unless it finds him a YO with respect to all such convictions. 3, upon determining that an eligible youth is a youthful offender, the court must direct that the conviction be deemed vacated and replaced by a youthful offender finding, and the court must sentence the defendant pursuant to 60.02 of the penal law. 4, upon determining that an eligible youth is not a YO, the court must order the accusatory instrument is unsealed and continue the action to judgment, pursuant to ordinary rules governing criminal prosecutions. So, continue the action to judgment basically means sentence the person. 720.25, YO adjudication, certain exemptions. Notwithstanding any inconsistent provision of law, 1, where a court is required to find the person is a YO, the fact that such person has been previously convicted of a crime or adjudicated a YO shall not prevent such person from being adjudicated a YO as required by such section. A YO adjudication pursuant to 170.80 of this chapter shall not be considered in determining whether the person is an eligible youth or in determining whether to find the person a youthful offender in any subsequent youthful offender adjudication. So, 170.80, I think that's a thing about like the prostitution, I think. I'm not sure, I'm guessing. 720.30, YO adjudication, post-judgment motion, and appeal. The provisions of this chapter governing the making and determination of post-judgment motions and the taking and determination of appeals in criminal cases apply to post-judgment motions and appeals with respect to YO adjudications whenever such provisions can reasonably be so applied. Okay, back to the questions. 725.10. Upon the filing of an order of removal in criminal court, all further proceedings, including motions and appeals, shall be in accordance with the laws pertaining to the family court, and for this purpose, all findings, determination, verdicts, and orders other than the order of removal shall be deemed to have been found by the family court. 26. 720.20 sub 1. Upon conviction of an eligible youth, the court must do what? What's the answer? The answer is they must order a pre-sentence investigation of the defendant. That's it. That's all they got to do upon conviction. 720.35. YO records may be obtained by the following, I think there's actually 7 of them now. 1. Designated education official. 2. The youth, adjudicated a YO. 3. The youth's agent. 4. Institution to where YO has been confined. 5. Department of Correction, with proper circumstances are required. 6. Probation Department. Proper circumstances are required. Next, Barbara is 13 years of age when she is arrested and charged with an act which, if committed by an adult, would constitute the crime of murder in the second degree, allegedly committed when she was 12 years old. Barbara cannot be arraigned in the youth part. This is true because a 12-year-old is not criminally responsible for any act. She has to go to family court. Next, Mary is 17 years old when she is arrested on December 22nd, 2018 for an armed felony, allegedly committed on October 17th when she was 16. Mary is an adolescent offender. So that is true. 720.25. YO adjudication, certain exemptions. Notwithstanding any inconsistent provision of law, 1. Where a court is required to find the person is a YO, the fact that such person has been previously convicted of a crime or adjudicated a YO shall not prevent such person from being adjudicated a YO as required by such section, and a YO adjudication pursuant to 170.80 of this chapter shall not be considered in determining whether the person is an eligible youth or in determining whether to find the person a youthful offender in any subsequent youthful offender adjudication. 720.30. YO adjudication, post-judgment motion, and appeal. The provisions of this chapter governing the making and determination of post-judgment motions and the taking and determination of appeals in criminal cases apply to post-judgment motions and appeals with respect to YO adjudications whenever such provisions can reasonably be so applied. 26. 720.20 sub 1. Upon conviction of an eligible youth, the court must do what? The answer is they must order a pre-sentence investigation of the defendant. That's it. That's all they got to do upon conviction. 720.35. YO records may be obtained by the following, I think there's actually 7 of them now. 1. Designated education official. 2. The youth, adjudicated a YO. 3. The youth's agent. 4. Institution to where YO has been confined. 5. Department of Correction, with proper circumstances are required. 6. Probation Department. Proper circumstances are required. There is 7. The 7th one is like a kind of a half one, though. It says, however, information regarding an order of protection specifically authorized by law, temporary order of protection or order of protection issued pursuant to 530.12 of this chapter, or a warrant issued in connection therewith may be maintained in a statewide automated order of protection and warrant registry pursuant to the executive law during the period that such order is in effect, or during which such warrant may be executed. Such confidential information may be made available pursuant to law only for purposes of adjudicating or enforcing such order of protection or temporary order of protection, and where provided to a designated educational official as defined for purposes related to educational plan, school adjustment, reentry. Destroyed at the time the student is no longer enrolled in the district. So if it happened when they were in middle school, like in 8th grade, it sticks around with them until they leave high school. When a person is adjudicated a YO and that conviction was vacated and replaced by YO finding was for a sex offense, as that term is defined in the mental hygiene law, all records pertaining to the YO shall be included in those records that may be obtained by the Commissioner of Health or Commissioner of Developmental Disabilities as appropriate case review panel and Attorney General pursuant to the mental hygiene law. So there's actually 7.5, because I'm counting that order of protection thing as like a half, 7.5, or you could actually call it 10.5, because these things about the mental hygiene law thing, it's the mental health commissioner, the developmental disabilities commissioner, the case review panel, and attorney general. So that you could either count as one big like mental hygiene thing if you already have that memorized, or you can count it as 4 separate ones. I'm going to count it as 7.5 because I already kind of have that mental hygiene thing done. So this is how it would go if you count it like that. 1, designated educational official. 2, the youth. 3, youth agent. 4, institution where he's combined. 5, Department of Correction. 6, probation department. 7, the mental hygiene thing. And the half is the order of protection or temporary order of protection, registry only. When a YO or his or her agent wish to obtain the record, such record should be made only to the court that sealed the record. All right, and that's it for 720 and 725. 722.00. The following statements are correct regarding the youth part. 1. All juvenile offenders and adolescent offenders shall be notified of the availability of services through the local probation department. 2. Services through the local probation department may include the ability of the probation department to conduct a risk and needs assessment utilizing a validated risk assessment tool in order to help determine suitable and individualized programming and referrals. 3. Participation in a risk and needs assessment shall be voluntary. 4. Based upon assessment findings, the probation department shall refer the juvenile or adolescent offender to available and appropriate services. 5. The probation service shall not transmit or otherwise communicate to the DA or the youth part any statement made by the juvenile or adolescent offender to a probation officer. 6. The probation service may make a recommendation regarding the completion of his or her case plan to the youth part and provide such information as it shall deem relevant. 7. No statement made to the probation service may be admitted into evidence at a fact-finding hearing at any time prior to a conviction. Some noteworthy things here is that it calls it the probation department in the first part of the paragraph, and then it calls it the probation service in the second part. 722. The following are true regarding the youth part. 1. Judges of the youth part shall be family court judges as described in Article 6, Section 1 of the Constitution. 2. The youth part shall have exclusive jurisdiction in all proceedings in relation to juvenile and adolescent offenders except provided in this article or 725. 3. The appellate division is responsible for designating judges authorized by law to exercise criminal jurisdiction. So that actually should read like this. The appellate division is responsible for designating judges who are authorized by law to exercise criminal jurisdiction to serve as accessible magistrates for the purpose of acting in place of the youth part for certain first appearance proceedings involving youths as provided by law. The presiding justice of the appellate division designates judges to act in the event that the youth part is not in session. If after arraignment there is reasonable cause to believe an adolescent offender committed a felony, the youth part must order that the defendant be held for the action of the grand jury. Question 7. If the DA makes a motion to prevent removal, the motion must be made within 30 days after arraignment of the adolescent offender. But if the youth is directed to report to the probation department and they do not, the time does not start running until they do. Question 8. If a juvenile offender makes a motion for removal to family court, the court in its determination shall what? Oh, you're going to have to cross off question 8. Question 9. Which of the following is considered an adolescent offender? 1. A 16-year-old charged with a traffic infraction allegedly committed on October 4th, 2018. No. Because traffic infractions are not part of the adolescent offender definition. 2. A 16-year-old charged with 511.1, a misdemeanor in the VTL allegedly committed on October 7, 2018. No, because this law exempts the VTL from the definition of adolescent offenders. 3. A 16-year-old charged with murder in the second degree allegedly committed on October 7, 2018. Yes, that person is an adolescent offender. Situation 4. A 16-year-old charged with a petty larceny, a misdemeanor defined in the penal law, committed on October 2nd, 2018. No, that person is a juvenile delinquent or an alleged juvenile delinquent, and they have to go to family court. 722.23. Following the arraignment of a defendant charged with a crime committed when he was 16 or commencing October 1st, 2019, 17 years of age, other than any Class A felony offense except for a drug felony, a violent felony offense, a felony offense listed in paragraph 1 or 2 of 1.20 sub 42 of the penal law, or an offense set forth in the VTL, the court shall order removal to family court unless within 30 calendar days of arraignment the DA makes a motion to prevent removal of such action. If the defendant fails to report to probation as directed, such period shall be told until the time as he or she reports to the probation department. 722.23. A motion to prevent removal shall be made in writing and shall be on prompt notice to the defendant. 722.23. If the DA makes a motion to prevent removal, either party may request a hearing on such motion. ... The hearing shall be held expeditiously. 722.23. If the hearing pursuant to question 12 is held, 1. There shall be a presumption against custody. 2. Case planning services shall be made available to the adolescent offender. 3. The court shall make a determination in writing or on the record within 5 days of the conclusion of the hearing or submission by the defense, whichever occurs last. Question 14. 722.23. Upon the arraignment of a defendant charged with a crime committed when he or she was 16 or commencing October 1st, 2019, 17 years of age, of a Class A felony offense except for those defined in Article 220 of the Penal Law, or of a violent felony offense, the court shall schedule an appearance no later than 6 calendar days from such arraignment. Question 15. 722.23. The purpose of the appearance described in question 14 is for the court to review the accusatory instrument and any other relevant facts for the purpose of making a determination regarding removal to family court. 722.23, question 16. This is a true or false. The defendant may waive review of the accusatory instrument by the court and the opportunity for removal in accordance with this section. But such waiver must be must be made in open court with presence and approval of his or her counsel and the court. Question 17. Judges of the youth part of the Superior Court, as well as judges authorized to preside as accessible magistrates, shall receive training in specialized areas, including but not limited to 1. Juvenile justice. 2. Adolescent development. 3. Custody and care of youths. 4. Effective treatment methods for reducing unlawful conduct by youths.